I'm Lisa Shepard, and I am the Executive Director of the Chief Justice's Commission on Professionalism. The mission of the CJCP is to enhance professionalism among North Carolina lawyers, judges, and law students, a mission which it has been doing since 1998. One of the ways that the CJCP does this is to sponsor this historical video series, which is a collection of video interviews of distinguished lawyers, judges, and professionals from across North Carolina. The CJCP began filming these video interviews in 2000 as a means to preserve the thoughts of these bar leaders on the legal profession and on professionalism issues. All of the videos in this series are available to you on the CJCP website and the CJCP's dedicated YouTube channel. We are so fortunate to have had many distinguished members of the North Carolina Bar over the years, and they have much accumulated wisdom to share with us. It is important to understand that the practice of law is a profession, and doing it well requires not only substantive knowledge that one gains in law school and from studying for the bar exam, but also the value of experience learned from other lawyers. I hope that this video series will give you not only a fresh insight into the person being interviewed, but also some meaningful information about how to be a better lawyer in your own practice. Enjoy, and remember, esse quam videri. Strive to be professional in all that you do, rather than to merely seem so.
Welcome to today's interview with Wallace C Harrelson, the Chief Public Defender of the 18th Judicial District. I'm Douglas Albright, formerly the Senior Resident Superior Court Judge of the 18th Judicial District, now retired. And it'll be my distinct honor and high privilege to conduct this interview with Mr. Harrelson, known affectionately to those in the court family here simply as Wally. Born in 1936, Wally was raised in Cherryville, North Carolina. Upon graduation from Cherryville High School, Wally attended Duke University, graduating there in 1959 with an A.B. degree in political science. Thereafter, he enrolled in the Duke University School of Law and earned his LLB degree there in 1962. Following his admission to the bar in 1963, he started his law practice in Guilford County, serving initially as a clerk solicitor, a hybrid position, basically the prosecuting attorney in the Guilford County Domestic Relations Court from 1963 to 1965. After this initial stint in public service, Wally then entered the private practice of law here in Greensboro, where from 1965 to 1970 he had a varied and successful general practice, including considerable court-appointed indigent work. On January 1st, 1970, Wally began what has come to be literally a lifetime commitment when he was appointed to be the first public defender ever here in the 18th Judicial District. He still holds this office after all these years. He has nurtured and developed one of the top public defender offices in the state. Wally's professionalism reaches way beyond his outstanding legal advocacy skill and his superior management style. Wally has continually been involved in volunteerism in a variety of community activities, embracing mental health, mental retardation, substance abuse, women's issues, and youth services. Indeed, the list seemingly has no end. In addition, he's served, I might add, for a time as a member of the Guilford County Board of Commissioners and was for a time chairman of that board here in Guilford County. Along the way, Wally's abilities and his talents have been recognized, and his contributions have been memorialized with many legal awards, including, among others, and this is just a sampling, the prestigious Outstanding Lawyer of the Year Award from the Criminal Defense Lawyers Association in 1983, the Order of the Longleaf Pine, awarded by Governor Hunt, and most recently, the extraordinarily prestigious Chief Justice's Professionalism Award. Wally was the 2008 recipient of this distinguished honor. His accomplishments are legion. His contributions are enduring and lasting, more than any other. His name is synonymous with the title of public defender. Well, Wally, just why did you decide on law as a career, and what influences from your early youth and your early schooling contributed to your decision to go into law?
Well, that's a very interesting question, Judge. As you have indicated, I grew up in Cherryville, was raised on a farm, and during my high school years, I was very active in the Methodist Church. And at one time, particularly my junior and senior years in high school, I thought about going into the ministry and being a preacher. Some people think that I'm still preaching, but even though I didn't go into the ministry. But any rate, even when I went to Duke in the fall of 1955, I was still thinking about the ministry, but then I began to have second thoughts as to whether or not I really had a true calling, so to speak, to go into the ministry. And I got to talking to some friends that I had made at Duke, particularly in the beginning of my sophomore year, who were considering going into the law field. And they said, well, why don't you come and consider joining a little organization on campus at Duke called the Bench and Bar, which was people who were pre-law. So I decided by the end of my sophomore year that that's really what I wanted to do, and started proceeding along those lines and taking courses that I felt might be of some help in going into the law field.
Were there lawyers or judges or court officials that assisted you when you first started practicing law? And if there were, what lessons did you learn from those folks?
Well, yes, there were judges and lawyers that were extremely helpful. I never will forget, I had come to Guilford County in 1963 as the clerk solicitor of the court, and I hadn't been here more than a month, and the judge who had appointed me, back then the judge appointed the prosecutor of the domestic court. Well, Judge B. Gordon Gentry was the judge, and within a period of a month, he had been fired by the county commissioners. At that time, the county commissioners chose the judge of the domestic court. He was replaced by an older gentleman by the name of William E. Comer. And I never will forget, I thought this man had the highest kind of ethics and was just a real professionally acting person. And he said one day, I want to have lunch with you and give you a few pointers. So I said, well, fine, Judge, when you want to do it? He said, well, why don't we do it today? So he said, I want to tell you two things you ought to remember if you're going to practice law. The first is, if something looks like it is improper and unethical, run in the opposite direction. And then he said, secondly, get along with your fellow lawyers. If you don't, you'll never succeed in the practice of law. Well, I have tried to follow those admonitions that he gave me then, and he was very helpful in getting me started. But when I entered the private practice, I met up with some real fire and brimstone trial lawyers Worth and Glenn Henderson, known as the Henderson brothers, and they were great in the defense of people charged with crimes, and they gave me a lot of pointers. And matter of fact, in the early years that I was practicing, sent me some clients. So as I think back on it, some that they didn't want to mess with, but at least it gave me some experience. And also I met up with Bob Cahoon, who was one of the premier trial lawyers here, and he was extremely helpful in making suggestions to me about how maybe I ought to try a case and this, that, and the other. A particular note were the clerks in the courthouse. They were just extremely helpful in getting a young lawyer that didn't know A from B on the right track and know where to head.
Well, let me ask you this. What led you to become a public defender here in the 18th Judicial District? What influences came to bear on you?
Well, that's interesting too. I had been the chairman of the Indigent Committee, which was responsible for getting lawyers to volunteer to handle cases. And Mark Short, who was a very prominent member of the bar and a member of the legislature for a number of years, said he had decided that the state needed to consider the public defender program. I hardly knew what that was all about, but he said, I think the time has come to establish a pilot project in North Carolina to see if we can't provide better representations for indigent people charged with crimes. So in the waning days of the 1969 legislative session, he got the law passed and to set up an office here and one in Cumberland County. This office began maybe a month or so before that one there. And so he came to my office, which was immediately adjacent to his office. He said, well, now I got the law passed, you get the votes. He meant the votes of the bar, because the bar is the one that recommended the candidate for public defender to the governor for appointment. So I got busy and got out a letter and knocked on doors and was successful in getting the most votes of the bar and was appointed effective January 1970 by then Governor Bob Scott. He made the first appointment. So I said to Mark, well, I'll try it for one term. Well, almost 39 years later, I'm still here. Pretty long term.
Yeah, and going strong, I might add.
Thank you, sir.
Now, Wally, you spend a lot of time with new lawyers in the public defender's office. You've hired many young lawyers, and you've gotten them started doing trial work in the courts. What sort of nurturing or mentoring do they need in order to become top-flight trial lawyers? And what general advice do you offer to them about how to be successful in their career as trial lawyers?
Well, first thing I tell them is this, more or less, words similar to this. You must provide your client with the best representation possible within the bounds of ethics and propriety. You can hear them uttering those words sometimes because that has become my stock advice to the younger lawyers. But I have a little different advice to give than maybe some practicing lawyers give to the new lawyer. I tell them, you have got to be practical in the practice of the law. You've got to know when to stop and when to start. And you need to decide whether or not you got a case or whether you haven't got a case. The main thing you need to do is first go and see your client and see what he or she says that they know about this crime. Many of them, when they get to see their client, they find out the client has run his mouth to the police, and there's not much they can do. I tell them, you know, you might have learned in law school about making motions. And I say to them, you've got to be practical about making motions. If there's something to make a motion about, then make a motion. But just don't file motions by the pound so that you just copy everything that somebody else has made and repeat it in your case. Be sure that it has something to do with it, and be sure that it has some meat in it. Otherwise, you're going to get a reputation for being frivolous, and the judges are not going to look upon that. But I say now the reverse of that is true. If there's an illegal search, if there is a confession you think is improper, then by all means proceed to fight that to the bitter end, to the appellate courts. But don't be impractical. The mark of a good lawyer, in my opinion, in civil and criminal cases is knowing when to stop. You can get run over. Now, in recent years, there has grown up a body of thinking which I disagree with. And that is that there are some people who feel there's something inherently wrong with plea bargaining. I said to one of these Henderson brothers one day, what do you think about this plea bargaining business? And they said, well, it came over on the Mayflower. And so I tell the lawyers, don't be afraid of plea bargaining. Sometimes you'll do a disservice to your client. If the water is deep and they have got confessions and they got eyewitnesses, then you better be thinking about some bargain that's going to get them the least possible time. So those are some of the general admonitions I give to the new lawyers.
Well, Wally, out there, there are a number of young law students considering career choices. What, if anything, would you say to them about becoming a government lawyer and practicing in the public sector, like becoming an assistant district attorney or an assistant public defender?
Well, I tell them this. Either in the public defender's office or the district attorney's office. Now, I say you get better experience in the public defender's office because it's more challenging. But in either one, the experience you get is unbelievable. And it can be helpful to you in a number of respects. If you want to make a career of being a public defender, as one of my assistants, Fred Lynn, has done, been there over 30 years, then it offers that opportunity. But it also offers you the opportunity to get the experience necessary to go into the private practice. I have a number of assistants, former assistants here, who are the leading members of the criminal defense bar. You know many of them. And so there is that opportunity. And then I say, in the event that you want to be a judge, I think that the opportunity provided in the public defender's office or the district attorney's office gives you a great opportunity maybe to move up to the bench.
Do you see a difference in the practice of law today as opposed to what you saw when you first began your practice? And if so, do you see a difference in the role that the attorneys play today in their communities as opposed to what they did when you started?
There are substantial changes that have come about over the years in the practice of the criminal law. When you and I started, you began as a solicitor about 6 or 8 months before I began as public defender. And we know then, back then, that there wasn't hardly any such thing as a motion. There wasn't hardly any such thing as discovery. A lot of lawyers tried cases by the seat of their pants, as they used to say. Go in and just try a case, square off, put 12 in the box. Don't worry about all this discovery business. Quite frankly, that worked pretty well if you had a solicitor, or later called district attorney, who had an open file policy. And you didn't have all of this paperwork that you have today. And when I first started, you had lawyers who engaged in great oratory. Some of the ones I've already mentioned, but many others that I could mention. They used to tell tales about in the old courthouse here in Guilford County. Before they had air conditioning, they opened the windows to cool off the place, and you could hear lawyers, prosecutors, and defense lawyers out in the streets. They were arguing and talking to the jury so loud. I think you moved away from that. Also, I think discovery and the discovery laws have been extremely helpful. But it has created a tremendous amount of work for the defense lawyer because you've got to file certain motions and make certain requests in a given time, and so the practice of law is, I don't think, quite as enjoyable as it was 30 or 40 years ago, because you've got so many things you got to be sure to take care of. The sentencing laws have changed. Back then, there was a lot of discretion in the hands of a judge. Now we have the sentencing law where everything is boxed in, and the judge doesn't have much discretion, and there's not much you can argue about when you get to the judge on the issue of punishment if you happen to get convicted. So I think there has been some real substantial change in the law. Now, I'm no expert in the civil area, but I hear from a number of my friends that there's been substantial change in the civil area. This business of billable hours has kind of taken over, and the young lawyer going in must have X number of billable hours, to the point, in my opinion, that both in the criminal and the civil area, the lawyers have had to work so hard and so many hours that they have not gotten involved in the community like I personally became involved, and you did, and most all of the lawyers 30, 35, 40 years ago. And as a result of that, I'm afraid that the public does not really get the real view of what a lawyer is all about, and gets the high calling of being a lawyer and concentrates on making money or working untold hours, and therefore does not get involved in community activities, which I think is basically very bad.
Let me shift gears a little bit here with you. Public service, community involvement. Has there been a decline in lawyers' participation in those areas? If that's a problem, what's the remedy?
Well, I think it is definitely a problem. I suppose there are a number of remedies or a number of things that could be done. First, I think that both of the bar associations, the North Carolina State Bar and the North Carolina Bar Association, and more recently and particularly the Chief Justice Commission on Professionalism, has attempted, and I think is succeeding in many respects, in getting people more involved in the community and pointing out and suggesting that needs to be done in order to improve the image of the lawyers in the community. I think probably the best bet would be for the local bar associations to become more active in doing so. I think that in recent years here in Guilford, there has been movement in that direction, where they have attempted to get members of our bar association involved in, for example, mentoring in the schools, or going in to speak to classes, or contributing to projects that's going to help kids that are disadvantaged in the schools and that type thing. When you and I started, lawyers were considered the pillars of the community, and they were the leaders of the community. And unfortunately, I'm afraid that we have gotten away from that.
Professionalism is a hard term to define. Different lawyers may have different notions about what constitutes professionalism. I just wonder if you have a definition that you like. Are there certain definitive words or terms that you think apply to professionalism, such as civility, honesty, integrity, candor, respect for the legal system?
Well, I certainly think that all of those words that you have used are words that are extremely important in considering what professionalism is. I've thought an awful lot about this since I was advised that I would receive this award, and I checked Mr. Webster, and I did not find any definition in there that looked like it was descriptive of professionalism as applies to the practice of law. But I came up with something that seems to me to be a pretty good definition of professionalism, and that is conduct yourself in a way so that you will gain the respect of the judiciary, the respect of the fellow members of the bar, respect of the community, and more particularly, the respect of your client. If you kind of follow that general guideline, it seems to me that you would be acting professionally, and it would include all of those things that you mentioned a minute ago. Sometimes integrity is used loosely, but it's a very important word. You see these politicians who run, they'll put on their card to the billboard, integrity. Well, I'm not sure they even know what that means, but integrity, as it applies to a member of the bar, in my opinion, is treating your members of the bar, fellow members of the bar, and most particularly the court, with respect. Unfortunately, and I tried to instill this in the new lawyers in my office, unfortunately, I'm afraid that the younger lawyers coming out, and I don't know why this is happening, have less respect for the bench than we did when we started out. They don't seem to have don't seem to think of the high position that a judge holds. You don't have to like the judge that you're appearing before. You might think he is hard-nosed as a Dickens and you would rather not be there, but you couldn't get out from under him, so you have to appear before him, but you need to have respect for him. And the same thing is true in the practice of the criminal law, where you have to butt heads every day with the district attorney. You might think he is an SOB, but by the same token, you have to realize that we operate on an adversarial system and treat the other side with respect. Don't shirk your duty to your client. I'm not suggesting that, but I'm suggesting that you can represent your client, but also be civil and be respectful and have respect for members of the bar. Back when you and I started, we would fight like cats and dogs, and after it was over, maybe go out and have a beer when I was still drinking. But at any rate, that's the sort of thing that you ought to do in the practice of law, whether it be civil or criminal. Don't hold grudges. Don't leave your case at the courthouse door.
Unprofessional lawyers. What do we do about them? What's the best way to deal with them?
Well, that's an interesting question. If they are unprofessional as opposed to unethical or doing something that's a violation of the state bar rules or the rules of professional conduct, I think a lot can be done by fellow members of the bar at a local level, the local bar association. I think the local bar associations could set up a committee so that if somebody appeared to be acting unprofessionally, you go to him or her and say, you know, we think, or the reports are, you are acting unprofessionally. We don't see that you violated any code of the state bar, but you're doing things that appear to be unprofessional. Could we talk about it? And if you're fortunate enough to get them to talk, sit down and talk and maybe save them from some other serious matter. We used to have here in Guilford County, and I served on the committee for several years, a local grievance committee, which was somewhat an arm of the state bar, where we tried to deal with folks locally before it got beyond control and the state bar had to bring them in and deal with them. So I think that trying to deal with them professionally for their unprofessional conduct is probably the best approach.
Wally, you are the most senior public defender in the state. You are the most respected public defender in the state. You've been involved with the public defender system from its earliest days. Literally, you go back to the beginning of the public defender system. You have, throughout your time, been an advocate for high standards in the public defender work. Can you identify what you believe to be your most important and lasting contributions to the office of public defender?
Well, it's hard to brag on yourself or talk about yourself or what your contribution has been. Um, Let me just go back a ways to when we started. This was a pilot project, and there's a lot of selling you had to do. It was something brand new. Many judges hadn't heard of it. If they had heard of it, didn't want no part of it. You had to sell yourself to the bar. You had to make the bar aware of what you were doing, and that you were not, as some defense lawyers back then said, in the bed with the DA, but that you were fighting for your client the best way you could. You had to convince the community that this was a new program and that it was a program that was necessary in order to provide the best representation possible for the client who was charged with a crime. And you had to try, which I did, to visit other bar associations. I was invited to Wake County. I was invited to Durham County. I was invited to Forsyth County. I was invited to Watauga County at one point in time to express why we felt that the public defender program was the best method of providing representation. I'll have to say that many times while I was received personally very well, what I had to say was not necessarily received very well, because the lawyers didn't want to hear nothing about no public defender, and that was going to take away from their practice. And so they had experience with certain programs like that, and they wouldn't want no part of that. But most particularly, you had to set a standard of representation which showed that you were doing what the office was set up to do, providing the best representation possible. You weren't doing anything frivolous. You were doing what needed to be done. And it took some doing when we got started, and for a period of time, to convince all of the parties that we felt we needed to convince that the public defender program was what needed to be spread throughout the state. So, after all that rigmarole I've just gone over, what I suppose, and I like to think is my major contribution, is that we set the standard for the state so that the legislature, in its wisdom, even though slowly, was willing to expand the public defender program into now what is, I believe, 15 offices from a meager 2 in 1970. Some people have had different opinions about the public defender program and whether it would work in certain areas. For example, it was a long time coming in Wake County. They should have had it years ago. But I think that, and when the Wake County District Attorney, public defender was appointed, he came to see us about setting up his office. That was true of a number of new offices that were set up. I like to think, and I hope not egotistically, but I like to think we set a standard so that the public defender program has expanded and hopefully will expand further.
I'm going to ask you to step back and take a bird's eye position, an overview position on the practice, and first I want to ask you as to what event or events do you recall that have had the greatest impact on our profession since you started practicing, if you can identify such events.
Well, I can think of a number of events. One of the biggest events that I recall was the establishment of the consolidated judicial system. When I started practicing here in Guilford County, you had JPs, you had the High Point Municipal Court, you had the Greensboro City Court, you had the Domestic Relations Court, and you had the Superior Court. And there was no organization whatsoever where you knew where to go and what to do. The jurisdictions of those various courts varied, and I'll give you a glaring example of what went on before the consolidated judicial system. You might remember this. It was a JP, rest his soul, he's no longer with us, but he had a nickname of Bumper, and he heard cases in the basement of a grocery store over here. And I went there one time in that basement representing a fella charged with rape. And to me, I thought it was a right serious case, and I was prepared to go to the Superior Court and all that sort of thing. And this JP said, well, let's put this thing off 6 months and see if y'all can't get along. Well, that would be unheard of today under the consolidated system for a JP to be putting off a rape case. But that's the sort of thing that went on. And you now have really 4 levels of court: Supreme Court, Court of Appeals, Superior Court, District Court. And you know what the jurisdiction of those courts are, and you know where you're going. One other event that has troubled me deeply is advertising. I think it has cheapened the practice of the law, and particularly cheapened the practice of the criminal law. You have people who, on a daily basis, obtain a copy of every citation that has been issued for speeding or whatever, and sends out a letter. I'll handle your case for $55, including the cost, or $65, including the cost. Frankly, I don't know how these people can afford to operate charging that kind of a fee. What it means is it is hurting many of your good lawyers who have to operate and have computers and good secretaries and office space and all of that sort of thing. I realize that the high courts have said that advertising is all right. I wish and I hope there is some way that this can be policed a little more than it has been policed to curtail and stop this advertising. You have things on TV, people advertising, which they more or less promise things they can't do. But I think that's one of the things that has hurt the practice of the criminal law in the worst kind of way. And I think probably that is true to a certain extent in the civil law, where you have this advertising going on a daily basis. It's, in my opinion, gets away from professionalism. It's almost unprofessional to be engaged in advertising, which probably is like selling used cars. And that to me is disturbing. The most important issue, in my opinion, facing the legal profession today is the reputation of lawyers and the way lawyers are viewed by the community in general. Now, I realize that there have been, in recent years, a lot of efforts made to try to get us away from I don't want to say a bad reputation, but get us away from being perceived as unethical or unprofessional. And I think the bar, state bars in recent years have made great strides in trying to improve the image of the bar. The Chief Justice Commission is one, as I recall reading their materials, one of the things that their mission should be is to try to make it known that the practice of law is a high and honorable profession, and we are professionals, and we're not people who are just trying to rob people of or to cheat them or everything of the kind. I don't mean to sound too strong in those words, but I do think that that is a great challenge for the bar to improve the image of the bar in the eyes of the community. And I think we're making progress, but still, in my opinion, a whole lot of work to be done.
Well, tell us about what you consider to be your most important case and why you consider it so.
Well, there was a fellow here in Guilford County by the name of Melvin Bennett. He was a young man who was mentally retarded. And there was he worked every day over at the University of North Carolina at Greensboro. The record showed he hadn't missed a day's work in years. Started working there when he was probably underage to work. Never had even a traffic ticket. There was a very brutal rape and murder that took place down here in the south part of the city, and they had to arrest somebody, in my opinion, because the pressure was being put on to arrest somebody. So they arrested Melvin, and they put him in jail, and he remained over here in the county jail for 2 years before he came to trial. The reason this case is so important, it has every ingredient of what can be and should be done and what should not be done in a criminal case. I solicited the help of my former assistant, Dave North, who has become one of the outstanding criminal defense trial lawyers, to help me in this case. This young man was charged with a capital offense where he could have gone to the gas chamber. Well, we got to looking into it and found out that there was a confession. He had been held a number of hours, and he confessed to having raped and killed this little girl. Well, I won't call any names, but the investigating officer, in my opinion, exerted pressure till he finally said, yes, well, I did it. And so we found out, and this was one of the first cases that DNA testing had been used in the courts, and it was considered to be a great weapon for the prosecution. But we got to checking into it, and we found out that the DNA had been done by the FBI lab in Washington, and it showed that semen found in the person of the deceased child could not have been the semen of our client. We employed, by getting some funds from the court, we applied to get an expert to come and see Melvin and make some determination about his retardation and his ability to make a confession or to understand his rights as they were read to him. Well, this psychologist from Chapel Hill, who was had been on the faculty there, visited with Melvin on a number of occasions. He was very deliberate in his analyses. He was very deliberate in determining what he found to be the state of mind of Melvin Bennett. He was called as a witness, and his testimony, I can't remember what his IQ was, but it was very low. His testimony was that he would say anything that he thought anybody wanted to hear, particularly cops, and that he was absolutely, completely and wholly incapable of making a confession and knowing what he was doing, a knowing confession, and that he wouldn't have any notion about what the rights he was supposed to have read meant. We called the FBI agent in Washington, and he said, "I will testify that there is no way that this semen found in the body of this young girl could have been placed there by your client." He came down a night early. Mr. North went to dinner with him, and they had a long conversation about what his testimony would be. And his testimony, he said, he testified in hundreds and hundreds of cases probably for the prosecution, but he simply testified as to what he found, and he testified on our behalf. Well, the jury got the case and was out probably an hour, hour and a half, and came back and found Melvin Bennett not guilty. Now, here was a young man that could have, under the law, be executed. But due to the diligent work of these experts, in my opinion, the experts are the ones that won the case. We worked on this case tirelessly for literally months because he sat in the jail for 2 years. And even though the DNA showed it couldn't be him, the prosecutor felt that, yeah, we've got to try him. He's guilty. We know he's guilty. He confessed. Well, to me, this is the heart of the defense criminal system. Here we were able to use everything that was available to us in order to free a man who was not guilty. And I'm convinced beyond any doubt he was not guilty. I saw him recently up here in the court, and he said he wasn't charged with any crime. I think he came with a friend up here on a traffic case or something. And I said, "Where are you working, Melvin?" He said, "I'm still over at the college." And so here's a man that, in my opinion, could have been convicted, and they didn't try him in the end for his life, but he could have been imprisoned for the rest of his remainder of his natural life. But at any rate, that is probably the biggest case I've tried.
All your days, you've been a remarkable public servant. You've been a leader and a fine lawyer. What has been the most important thing or things in your life that you would be comfortable in sharing with others that they might want to emulate or might want to use as a pattern for their own lives?
Well, there is something that I have never shied away from discussing. A little over 25 years ago, as you will recall, I decided, upon the suggestion of a number of my friends, judges, prosecutors, this, that, and the other, about 20 of them came to visit me in Cone Hospital and suggested that I might have a drinking problem. And so, at any rate, they suggested I go to treatment. And I said, "Oh, my goodness, how long does this treatment take?" He said, "Well, it'll take a month." And I said, "Well, what is going to happen to all these rapes and murders that I am representing?" And they had the district attorney there, Lamar Dowder. And he said, "They'll be continued as long as they need to be." And I said, "Well, what in the world is going to happen to the Democratic Party?" I was the chairman of the party at the time. Bob Cahoon said, "If you don't quit this drinking, you ain't going to be no Democratic Party." And I said, "Well, who in the world is going to run the office? I don't have anybody can run that office." They said, "Oh, yes, Fred can do it. He's been there a while. Fred Lynn, he can run the office." So I took a fast ride. It was known as an intervention. It was the best thing that ever happened to me in my life. That was 25 years ago. The whole thing really horrified me. The doctor first had said, "Well, we're going to say that you need to get some rest." You had gone away for rest. Well, somebody, way or another, the news media picked up on it, and I was out in front of the building at the treatment center on a Friday when I saw this newspaper recorder go in the front door, and I said, "Oh, school is out." But at any rate, I said to the girl I was talking to, "Get in front of me. That's a newspaper reporter." She said, "So what?" Well, I will not go into all of the great details, but we decided to give a statement upon the advice of several of my friends that I had found it necessary because of possible physical harm and what have you, to enter treatment for alcoholism. And so I did. I stayed there 28 days, and I have been very active in various programs. Have served and presently serve on the board of Fellowship Hall, which deals with substance abuse, one of the best treatment centers in the country. I helped establish the Guilford County Substance Abuse Center for Indigents, and have done a number of things. I simply say that to say this to young lawyers or any other lawyers who might be having problems. It will be, if you have a problem or think you have a problem, to do something about it. It will be the best decision you made in your entire life. Could save your life, could save your reputation, and could possibly save your bar license.
Ladies and gentlemen, this concludes the historical video interview with Wallace C Harrelson, Chief Public Defender of the 18th Judicial District.